I'll now call the next case of 116223, State of Kansas versus Tabitha Carter.
Please the court and counsel, Assistant District Attorney Matt Maloney for the state. Your Honor, if I could reserve 3 minutes of rebuttal.
3 minutes is granted. Thank you.
Thank you. A very brief factual background of the case that we're here to discuss today. The defendant committed an armed robbery at a Dollar General store in Wichita. She entered the store wearing a clown mask, a tan work suit, and black gloves and boots. She also was armed with a taser at the time. One of the employees of the Dollar General saw what she thought might be a gun in the defendant's hand. After the employees put money in a bag at the defendant's demand, the defendant then displayed the taser and fled the store with approximately $3,400.
Mr. Maloney, the first employee who saw what she thought might be a gun was the one that under the state's theory was the internal Confederate, right?
Yes, that was the state's. It did appear that this person was in fact in on this
Her
crime.
position at trial obviously was I had nothing to do
Right.
with it, and she threw the defendant under the bus.
Yeah,
In
she
fact,
was the one who
Confederate.
testified that she saw something that she thought might be a gun.
And that happened before the money was out.
Yes, exactly. That was when the defendant had first entered the store before she had the money, and then it was the other employee who saw the taser as the defendant was fleeing the store with the money.
Okay, I don't want to interrupt your factual recitation.
No, that's a pertinent question.
I have more of a procedural question.
Sure.
If I may. The judge said what the judge said on the transcript in terms of the registration requirement. Everybody's stuck with that. But the journal entry used the language from the statute, didn't it? It said a deadly weapon used in the commission of the offense.
I believe that's correct. Yes.
Okay.
Yes.
Thanks.
So after the defendant was convicted of aggravated robbery, the court made a finding that it was a person felony and that there was as Your Honor pointed out, the word that he used at sentencing was a dangerous weapon, but the journal entry indicated deadly, and as a result, the defendant was ordered to register. On appeal, among the issues raised by the defendant was that the registration order was improper. There were multiple arguments made by the defendant, but the argument that the Court of Appeals panel found to be persuasive was that this was not proper for registration because it was not a deadly weapon that was used in the commission of the crime. And the court's analysis was essentially that a taser does not qualify as a deadly weapon. And in answering that question, the Court of Appeals applied an objective standard in looking at whether a taser is in fact a deadly weapon. The panel acknowledged that another panel of the Court of Appeals in State versus Franklin had come to the opposite conclusion and had decided that a subjective test should apply based on whether the victim perceived the weapon, reasonably perceived the weapon at issue to be a deadly weapon, and if that was in fact the defendant's intent. Not surprisingly.
So it's subjective on two people's part? I mean, I have a little, I'll be honest, I think that drawing the line between these two tests is pretty tough.
Right.
But assuming such a line can be drawn,
right.
When you talk about the subjective test that you advocate for and that Franklin adopted, the subjectivity occurs on the part of two people. Am I correct? Not only the victim reasonably perceives it to be a deadly weapon, but the
intent of the defendant.
The intent of the defendant or the offender or whatever is also that it be perceived in that way, or that it is, I mean, how can someone intend something? I'm really struggling with what the subjective test is supposed to be about. So maybe you can
I think looking at, in Franklin, there's some language quoted that the subjective test to determine a dangerous weapon within the meaning of the aggravated robbery statute depends upon the intent of the robber and the reasonable belief of the victim. And so I think there is an element there of both you do look to both the defendant's intent and the victim's reasonable belief. And I think that those will generally be linked.
Okay, so let's assume that's the test here, just for purposes of argument. What is the evidence in the record that that test is met?
Well, I think just the fact that that the defendant came into this store, did have the weapon displayed. I think obviously there was the testimony from, as you pointed out, the co-worker who might have been a part of this, but nevertheless that testimony was in the record that she saw this weapon when the defendant entered, certainly before the robbery was complete, and in fact before it had even began. So the defendant had this weapon, had it displayed up front, and then at the time that she got the bag with the money and was leaving the store, she then not only had it, but I think that was when the other employee testified that she in fact held it out and displayed it.
As she was exiting.
Yes.
So one of the points your opponent makes in this case is that the person who saw the weapon at the beginning of the crime is not, according to the state's theory, is a Confederate, not a victim. Does that make any difference on the subjective? If we have to look at the subjective, reasonable belief of the person who's the victim, the one who the state says is actually a victim of the crime doesn't see any kind of weapon until right before she leaves the store. Right. Is that enough?
Well, I think two things. I think that even if that is the only evidence you look at, I do think that would be enough, because the crime was not complete at that point, and the victim that victim did testify that she feared that she was about to be tased. And from the state's perspective, as we argue, is that the taser itself, even if there's no question and everybody involved thought that it was a taser as opposed to a real weapon, our position is that would still qualify under the statute, because while admittedly a taser is not as deadly as a handgun, and I think that's something that the Court of Appeals panel in this case seized on, is they said, well, granted, a taser can be deadly. There are examples of tasers proving fatal. They said, but it's clearly not as dangerous or as deadly as a real gun, and it's not necessarily the intended purpose of a taser to be deadly, and therefore they found that it didn't meet the definition. And my response to that would be, granted, it's not as deadly as a gun, but the statute doesn't say that it only applies to the most deadly of weapons. If that were the theory, I guess we would just say, well, whatever the most deadly weapon you can come up with qualifies, and nothing else does. Given that rationale, you could say a knife isn't a deadly weapon because it's not as deadly as a gun. So I think given the panel's acknowledgement that tasers can in fact and have in fact proven deadly, and certainly have proven to be capable of inflicting serious bodily harm, I think that even if you were just to look at that one victim's testimony and her fear that she was about to be tased, I think that does qualify. Now, we would also argue that despite the fact that our theory at trial was that the other employee was in fact in on this, I don't think that then you can just say, well, then we have to disregard her testimony that she thought it was a gun. Clearly, the jury, as you pointed out, that witness at trial denied being part of it. And so the jury heard her testify, indicate that she was not in on this crime, and did hear her say that she feared that it was an actual gun. And so I think that is also evidence that at least should be considered. The fact that there was clearly testimony at trial from one of the people in the store that they feared that it was a real gun. And I think just in general as to our perspective on why this subjective test should apply, to me, the Franklin panel got this right. I think you look at the purpose, the legislative intent behind registration, and it's to protect public safety and to...
That's true of all criminal law. isn't it? I mean, really, it's all, the whole body of law and procedure is about protecting public safety.
Right.
So that doesn't really tell us very much, does it?
Well, except the fact that this is specific to saying that when a weapon, a deadly weapon, is used, that then those offenders are going to be subject to this additional requirement beyond just their sentence, that they're going to have registration required. And our position is that when somebody, clearly the defendant went into the store using the taser for a purpose. She wanted to make it easier to commit the crime. She wanted to frighten the victims into compliance. And in that scenario, obviously, while the Court of Appeals panel in this case can sit back and do research on exactly what a taser is and how lethal it is and what its design is, as a victim, when you're confronted with a masked intruder wearing dark clothing and armed with a weapon like this, you have seconds to determine what's happening here. And when a victim is in that situation and faced with what very well could be a quote-unquote real weapon, the chances of violence and harm to somebody increase exponentially.
Well, let's get the subjective belief of what the victim believed was a real weapon, is what you said. What if I have this Sharpie and I have it concealed like this and it looks like a gun? And the victim may very well believe that it's a gun, and basically you could be making the same argument here based upon the concealed weapon that it actually turns out not to be anything but a plastic piece of a writing instrument. What's the difference?
Yeah,
in your argument, what's the difference?
Right.
So this is a dangerous way. This is and I want to ask you too about dangerous versus deadly, but
right.
Let's focus on the purely subjective belief on the part of the victim. Isn't that a problem here?
It's a good question, and that type of hypothetical was one thing that I thought about as well as I was working on this, and I think that under that test, clearly the defendant's intent in that situation would be to make the victim think that he or she is armed with a weapon. And under your hypothetical, if the victim in fact does think that, then I think that an argument, while it might seem perhaps unreasonable, I do think there is an argument to be made that would qualify. And I think it's because, again, by doing that, by taking those actions, by wanting to scare the victim into thinking that he or she is armed, the defendant is the one who's created that situation where the risk of violence is that much greater, not only to the victim, but to the defendant, him or herself, if the victim were to be armed and pull out a weapon or just try and fight back, or to any bystander that happens to be nearby at this time. Even using something that we wouldn't normally consider a weapon or a deadly weapon does so significantly increase the risk of violence, and it's at the defendant's own doing. So while it might seem at first blush maybe a little bit of a stretch, when you're looking at the purpose of saying that somebody should register in this situation, I think that if a defendant chooses to take those actions, he or she is doing that with a specific design in mind. They've come to the conclusion that their ability to carry out this crime will be enhanced by frightening the victim into thinking that they are armed with a weapon. And so whether it's a highlighter or a pen, or sometimes even just their finger, I guess, putting it in their pocket or concealing it, I do think that in a situation like that, it is appropriate to say that the defendant has taken actions that show his subjective intent, and then if there is testimony from the victim that they believe that was in fact a deadly weapon, I think that that's a reasonable interpretation of the statute there. And
briefly, before you sit down, there was at sentencing, he said that it's clearly a dangerous weapon, but that's not consistent with what was in the journal entry. What do we do with that? Is that typically it's the pronouncement that carries the day, and that's not, the dangerous weapon is not per se deadly.
Right. I think the panel was correct in basically saying that when you look at case law interpreting those two terms, they more or less have been interpreted to mean the same thing. And so any misspeaking on behalf of the judge at that point was largely inconsequential. And I would also note that to the extent that ruling on the Court of Appeals part went in the state's favor, the court did not find there to be a problem with the use of the phrase dangerous weapon. And the defendant did not, to my recollection, cross-appeal that particular rule or cross-petition that. And even if the defendant did, that was not granted. And so I think that issue, to the extent the Court of Appeals ruled in our favor, would be resolved at this point. I see I've concluded my time, and I think I have made the argument that I intended to make. So unless there are further questions at this time, I would cede the remainder of my time for rebuttal.
Any questions? Okay, thank you.
May it please the court, Jennifer Roth from the Kansas Appellate Defender Office, appearing on behalf of Tabitha Carter. Before I respond directly to some of the arguments that the state made, I guess it's my own version of a 60-second overview. And that is that the reason we're here is the state's petition is asking this court to consider one thing, to consider using the subjective approach that's utilized in State v. Franklin. They contend that's the better test and should be adopted by this court. But as we can see from the arguments that we've made and the case law and the other concerns, the state's issue is actually with the legislature and not this court. The 2006 legislature created E2, 224902E2, and if the state wants a different test, other than what the plain language of that statute provides, it needs to take it up across the street. It's our belief that this court cannot grant the state the remedy it seeks. The first reason being the plain language trumps the policy that they are advocating for. To kind of respond to some of the things that the state said, first of all, about the journal entry. It's true that there's a box on the journal entry that in this case was checked. But as Justice Rosen mentioned, the prevailing rule is you go by what is pronounced from the bench, not what box is checked on the journal entry.
That's
The
true for
problem-
sentencing. I'm sorry.
Well, I think we were going to ask the same question, it sounds like.
That's true for sentencing. But a majority of this court has said that the registration requirement is not a part of the sentence. Does that make a difference?
That's true. All of this takes place at the sentencing. In fact, in this instance, the district court didn't even follow the statute that says you're supposed to notify the defendant. If the state asked, notify the defendant upon conviction. This is literally the last thing that happens at this person's sentencing. And so while that is true, I'm wondering then what tests do I mean, is there, I don't know in civil law if there's something that says if the judge says one thing on a bench, from the bench and something else in the order, that the order prevails or somehow cancels out what the judge said. Because unfortunately I don't know very much at all about civil law. And so while I understand that those cases are about sentences, I still have to believe that there's a rule or a law that says what the judge says from the bench controls, or at least really plays a big part, versus what they box that maybe they don't even check themselves, but perhaps is checked by the state on a journal entry.
But don't you have to pursue that issue through a cross petition for review, given the Court of Appeals holding?
No. First of all, is this about the dangerous first? No, first of all, I prevailed in this case. So even if personally, I think I should have won on a different ground, as I figured out later and set out in my supplementary brief. I think I should have won on a different ground. But because I did not have anything to be aggrieved about, I was not able to file. There was nothing for me to petition. And so, no, I don't think I have to petition that a box was checked on the journal entry form, especially when I don't recall the Court of Appeals making anything of that, which this does not exactly follow from that. But on the topic of what the Court of Appeals did decide, one of the last things that the state mentioned was that I didn't cross appeal about the dangerous and the deadly, and that the Court of Appeals found those to be interchangeable. That's not what the Court of Appeals said. What the Court of Appeals said was that they were bound by this court's opinions about what the definition of dangerous and that this court in older cases has used those things, used the definition of deadly and the definition of dangerous and deadly somewhat interchangeably. So this court can decide what it wants to do about that in this particular context. And I believe this court's already signaled to us things that you've been thinking about when you said in Marinelli that there are potential asymmetries in what is required for the state to prove a crime that it has charged versus what it has to prove to get a additional thing under a civil regulatory scheme. So at any rate, this case is one of those potential asymmetries. At any rate, the other thing I'd say about the journal entry is there are other things in there that are wrong under the registration part, but instead of getting picky like that, I will say this about the journal entry. When you look at the box, the words deadly weapon are in all caps, bold, and underlined. And I feel that though what the state is asking this court to do is that since the legislature didn't put deadly weapon in caps, bold, and underlined in 224902E2, that somehow or another that this court can use a test that's a subjective test that's not called for by the plain language of that statute. And that simply cannot be. The other thing, to address something that a number of the justices talked to the state about, is the subjective test and how it's, in this case in particular, tricky, because you do have the subjective intent of the robber, who we'll call Ms. Carter, because we could strew the evidence in the state, and the subjective belief of Ms. Sanders. And so the state's theory wasn't that, it was not just, oh, that might have been what we are. That was the state's theory. The state's theory was this was a sham robbery. That's why they only charged Ms. Sanders as a victim. That's why it's only what Ms. Sanders' subjective belief is appropriate and to look at, not what her partner in crime did. She's not even charged as a victim. So even under the test the state wants you to follow, the other person that testified, this other store employee, is not a victim whose subjective belief you take into consideration. But it makes me wonder if the state's theory is that Ms. Sanders, well, this was a sham robbery. No, sorry, Ms. Carter was doing a sham robbery. Then under the state's own theory, she is never going to use that weapon. She was not using it to further to commit. She was not using it to commit a crime. She was using it to make it look real, which in fact is even something that Ms. Sanders testified to, which is she kind of just showed it to us like so we'd know she had it. So it makes me wonder if this is the test that the state's advocating for, does what my client's alleged intent and what Ms. Sanders' intent cancel each other out? And so we don't have a subjective intent anymore. It just sort of illustrates in this particular case, because of the facts of this case, it makes that test even trickier.
Sanders was the actual victim, according to the
That's
state.
correct.
And did she testify, I was afraid I was going to get tased?
She did say that.
Okay, so if the subjective test is what's controlling, we at least have her fear that she's going to be tased, which just takes us back to what evidence is there that a taser is a deadly weapon.
Right? Exactly.
And as to the robber's subjective intent, is it that they intend to actually employ the weapon, or that they intend to scare people to give them the money because they have a deadly weapon?
They want, the person wants you to believe that you need to give me the money, that I need to just make you think I have a weapon to make you give me the money.
So your argument about the sham robbery doesn't apply to the subjective intent of the robber?
Because the
Because-
subjective intent is just to instill the fear, right? That's what they're really talking about.
They're not intending it to be deadly or not deadly, it just is or
Right.
isn't.
Well, and the other
They're
thing
intending
is,
to scare somebody.
right, I guess the other thing that I think about is that under the state's theory and the evidence it presented, Ms. Carter was always going to get the money because the partner in crime was going to make sure of that. And so, but I still see what you mean about
Yeah.
what
And
exactly
there's
is
no
the-
way to know that, obviously, if this
Right.
diminutive Ms. Sanders thinks she can be a hero, then things can go pretty haywire, no matter what the defendant thinks about her Confederate's complicity.
Right.
It's
But-
an intent to scare. It has to be an intent to frighten people into giving up their goods.
They're giving up their good, right. And maybe I better go to my stronger point, which is that it's not a deadly weapon.
No proof of a deadly weapon. That's really your horse.
Right, exactly. And in fact, speaking of things that, that the state did not petition, or that people didn't petition, the state is asking you to adopt a certain test. The state did not petition this idea that a taser is not a deadly weapon. And so that it's not a deadly weapon, and that there's no challenge made to the Court of Appeals finding in that regard.
I've been worried about this. It seems to me you're trying to get us to a place where we have to start, or the state would have to start proving that the knife used in a crime, was sharp enough or had a point on it, or that a baseball bat, which, can be used, it can be used to hit baseballs, but can also be used to break open heads. How do we differentiate those kinds of things in your world?
Well,
Thought.
what the plain language says and what I'm advocating for does not change anything about how you charge crimes, what crimes you can charge, etc. What the plain language says and what I'm advocating for is, if you want to use a statute, aggravated robbery, these other aggravated crimes, they're not enumerated in the statute, right? That's why we're here, because the court has to make a finding. And so if the state wants to ask that somebody be required to register for 15 years because they used a deadly weapon, then the state would have to produce evidence that they used a deadly weapon in order for the court to make a finding to support that request. And so I don't believe that what the plain language provides and what I am advocating for it's not going to change the fact that, do you have to prove if a knife was sharp enough in an ag assault or this or that? We're not talking about crimes. We're talking about what is the consequence to this person in a civil regulatory scheme.
I understand that, but
Right.
I'm just saying, so use my example of a baseball bat. How does the state prove that registration might be required if the defendant committed a crime with by showing the victim a baseball bat?
I guess, I suppose they could talk about, they could call that person to testify about, no. I guess they'd have to put on some sort of witness. They'd have to, I don't know.
Why isn't it enough just to have the fact presented that the bat was used? We're talking about a fact finding, right? Even employing your plain language approach, we're talking
Okay.
about a judicially made fact finding that a deadly weapon was used.
Right.
Wouldn't we just employ a sufficiency of the evidence type test on review?
Well, that's the way I think of it, is that the district court judge is basically going to have to do that. I mean, because I'm thinking about there's different ways I can use a baseball bat. Do I have it at my
Right.
side and not say anything about it?
Well, that's still, you're still showing up with it, and the victim still sees it.
No,
The
no, I'm
deadliness
talking
can
about
be
what-
proved by circumstantial evidence.
Sorry?
Deadliness can be proved by, I think what you're suggesting
Yes.
is that deadliness of an object
Mm-hmm.
can be proved by circumstantial evidence. You don't necessarily need to have direct testimony from a witness who says,
Right.
last year 400 people across the United States were killed by getting hit in the head by a baseball bat. You don't
Right.
need that.
No. But what I do think matters is, right, I guess you're right, the facts that surround that object. And so it's one thing because the test isn't about what the other person thought. The test is like, is this thing that I either have at my side or I'm wildly swinging around while wasted or whatever, that you still have to decide whether in the manner it was used, however exactly that, from the manner used is calculated or likely to produce death or serious bodily injury. So it is a fact question, but you can't just per se say a baseball bat is a deadly weapon. And that, I believe, is what happens all the time. But that is not how that would work. The state would still have to produce evidence, whether it be circumstantial or direct, that the manner in which this item that they want to be declared to be a deadly weapon, from the manner it was used, is calculated or likely to produce death or serious bodily injury.
But are there categories of weapons that are per se deadly?
I said that. I said that guns were per se deadly, and then
That's it.
and I decided that actually I don't even believe that, because I've read some core cases where they talk about a gun that doesn't actually work,
Yeah, what if
or
it's
things
unloaded?
like.
Or
Sorry.
it's not loaded.
Right. So maybe it's not a deadly. Right. So basically, I'm backing away from the fact when I said a gun was a deadly weapon. I don't believe that. That you cannot categorically say that something that is a firearm is a deadly weapon. I believe that now.
We're sort of, I don't mean to prolong it, but we're sort of talking about this like it's a question of law. Like we can determine as a matter of law what's a deadly weapon and what's not. But I'm still stuck on it's a fact finding. And how do we, don't you have a pretty high hurdle to get over for us to overturn a fact finding?
I don't want you to overturn anything. I want you to overturn
Didn't
anything.
the district court make a fact finding here?
Yeah, they said it was not a deadly weapon. I won, and they said it wasn't a deadly weapon. So I don't want you to overturn.
Am I misunderstanding? That was
It's
what the
not
Court of
from the
Appeals
district
said.
court.
The Court of Appeals
Right.
overturned the fact finding of the district court.
Oh, I'm sorry. Yes, that's correct. That's right. Sorry. That's right. Because there wasn't any evidence that it was a deadly weapon, and that you can't use dangerous to mean deadly. You can't use those things interchangeably. But anyway, I see that I am out of time, and so if nobody has any further questions, hopefully I've said all the things I wanted to say. Thank you.
Thank you. Mr. Mullen?
May it please the court. Just a couple of brief comments in response to arguments that I heard counsel make. One thing that the defense is essentially arguing is that the statute is clear and it doesn't support a subjective test. And I think that the panel here seemed to somewhat agree with that argument. I would argue that that's anything but clear, and I think that's evidenced by the fact that we've had 2 Court of Appeals panels that have addressed this issue, and 6 judges have come to different conclusions. And I think the panel in this case even kind of acknowledged the fact that this was a case that was probably appropriate for review from this
Didn't one of
court.
the panels conclude that basically came up with that conclusion because they thought it was inconsistent to have a different test for proving the crime versus registration? And what's wrong with having 2 different tests? What's wrong with having more of a subjective kind of basis for that when you're trying to prove the elements of the crime and what the victim actually went through versus what is required for registration, which seems to be pretty straightforward and more objective? What's wrong with having two different tests?
Well, I think part of the panel's focus in this case was that what they thought was especially inconsistent was that the defendant was trying to use the test that applies to aggravated battery and ignore the test that applies to aggravated robbery when in fact she was convicted of aggravated robbery. And so I think that was part of the inconsistency that the court focused on.
In Franklin.
In Franklin,
Yeah.
I should say, yes.
Yeah.
As far as whether there's anything inherently wrong with it, I mean, certainly the court could go that way.
I mean,
if
they're
it
two
chooses.
different things. That's
Right.
So
But I do think, though, for the defendant to just say, well, or for the panel in this case, for that matter, to say, well, the statute doesn't say that it's a subjective test, so therefore it's not. I guess I would flip that and say the statute doesn't say that it's an objective test. The statute itself doesn't specifically say one way or the other, and I think that's why we've had two panels of 6 judges, one of whom was on the Franklin panel, that have come to different conclusions. And I think that right there shows, it might not show which side is right or which side is wrong, but it at least shows that these are both reasonable interpretations, and it's not as clear-cut as the defense would suggest. And so given that, I think it then is appropriate to look at things like legislative history and the purpose behind registration. And our position would be that when you do use a weapon in this way, that you are intending to facilitate the crime by making the victim think that you're armed with something that could kill or seriously injure them. And then just one final thing to note. Counsel questioned whether the state's petition properly preserved the issue of whether a taser is in fact a deadly weapon, and I would just, obviously your honors have already read the petition and can do so again. I think when you look at that, the state's position in that petition was clear. We were arguing that the subjective test should apply, and that under that subjective test that the weapon that was used in this case does qualify for that. So I would strongly disagree with any assertion that we have somehow not petitioned that issue. To wrap up, our position simply is that the Franklin court got it right, that interpretation of the statute is the correct one, and we would ask for that reason for this court to reverse the Court of Appeals and to reinstate the district court's decision.
Any other questions?
Thank you.
Thank you, counsel. The court will now take this matter under advisement, and we will be